record. This is the matter of the state of Florida. The matters, the state of Florida versus Hakeem Robinson. They're 2020 CF 8232 and 21 CF 2332. And the defendant is present with counsel appearing on Zoom. But let me ask Mr. Robinson, do you see your attorneys, Ms. Kawass and Mr. DeCoste, on the Zoom screen?
Yes, ma'am.
All right. And can you all see and hear your client seated at counsel table?
I can, Your Honor. Yes, thank you.
Okay. And we have both Mr. Cooper and Mr. Atkinson present, each one for their respective case. And we are here for a hearing on the motion to compel filed by the defense. And I have reviewed both the motion along with the response from the state. And so we have set the matter for a hearing. Are both sides ready to proceed?
Yes, Your Honor.
Okay. And to be clear, the motion to compel, well, where is it? Was it filed in both cases or just Mr. Atkinson's case?
Both cases, Your Honor.
Okay, that's what I was wanting to be sure of. All right, then it is your motion. You may make argument first.
Thank you, Your Honor. And hearing that the court has, no surprise, reviewed the motions, I will keep it brief and I'll keep it pinpointed to the situation. Dominique Barner and Shenard Cannon are the two witnesses that we're talking about here. Essentially, what the defense is trying to get is a list of all those cases where both of these individuals have testified for the government, including those cases, of course, that they're testifying for the government now. In the government's response, they tried to differentiate in between a co-defendant and an informant. And they said that these two gentlemen are more like co-defendants, and that is incorrect. Dominique Barner, although he should be a co-defendant in the second murder case, Mr. Atkinson's murder case, he is not a co-defendant in that case. He was not charged in that. Same thing with Shenard Cannon. Shenard Cannon isn't a co-defendant, is not charged. If anything, these are informant witnesses. They qualify more as informant witnesses. Shenard Cannon was taken into custody in May of last year. He was let out of custody soon thereafter. And the in-between was that he met with Mr. Atkinson and gave a statement. Now, unfortunately, we didn't get the recording until I think November of last year, but that is more in line with an informant. But even if they were co-defendants, we are still entitled to know all of those times that these witnesses have testified for the government are. Now, Mr. Atkinson, and I referenced it in my motion, I put one of his email responses to me where, for instance, Dominique Barner is a cooperating witness on certain cases, and then on other cases, he's just a witness. But that's not the way that it works. As Dominique Barner takes a stand for the government in any case, in his mind, he's thinking, I need to do right by them to get the best deal, before Your Honor when he ultimately goes in for sentencing, to get the best recommendation from the government. That goes to a fundamental aspect of cross-examination when he takes a stand in our case, the fact that he has a motive to say whatever the government wants him to say. Not saying that they're doing that, but in his mind, he has a motive to do whatever he can to be in the good graces of the government. Now, I do know of, or I believe, and the government can clear this up, but my understanding is that Shenard Cannon was actually a witness against Dominique Barner. We don't have him listed. My understanding is also that Dominique Barner, and this is not an exhaustive list because I believe there are other cases, that Dominique Barner is a witness in the case of State v. Germain Dubose. Germain is Germaine, last name Dubose. But most importantly, the response
I'm sorry, who was Cannon or
Barner?
Okay.
Correct. Just the response that Mr. Atkinson gave me in the email where he differentiated the cases that Dominique Barner is cooperating on versus the cases where he's just a witness, that is my concern, that there are other cases out there. So whether they're informants, whether they're cooperating co-defendants, the defense is still entitled to know all those cases that these witnesses are testifying, although it's not the government's belief that it's in exchange for anything. In the mind of those witnesses, it absolutely is. So that's the extent of the argument. And then there's some additional stuff under the rule that we're entitled to, like the priors, which I haven't gotten for Mr. Cannon, that we'd like to have all of the priors. That's all, Your Honor, and thank you.
Okay, thank you. I'll hear then first from Mr. Atkinson in terms of the priors for these two folks and any and all cases in which they are a cooperating witness.
Yes, ma'am. And I'm trying to find it. I believe that Mr. Cannon's priors have been listed in Brady in one of the disclosures. I've listed that he has 4 prior felony convictions under Brady in the state's 6th supplemental discovery.
Okay.
As to the cases that they're cooperating in, I guess the easiest thing to do is just to explain kind of each of their situations. So without distinguishing as to whether or not they're informant witnesses, cooperating co-defendants, just to clear the record. As it relates first to Mr. Dominique Varner, there are 5 cases in total that the state is aware of, and all of these have been addressed in discovery through various supplemental discovery exhibits, which I listed in my response. So the first is in 2017. He was a kind of a co-defendant in the case of Mark Clayton, where he and Mr. Clayton were both arrested in the vehicle. Each of them were charged with a firearm. Mr. Varner agreed to give sworn testimony in Mr. Clayton's case. He did give sworn testimony. He never testified in a trial or a hearing. It's my understanding that Mr. Clayton's case went to the federal prosecutors, but then he was rearrested on a robbery charge. And then the robbery charge was fully independent of Mr. Varner. Mr. Clayton was charged and found guilty in that case. And so Mr. Varner never testified other than giving that sworn statement. There is the case of Jermaine.
So that case is not pending currently, nor is it expected that Mr. Varner will give future testimony?
That's correct.
Okay.
There's the case of Jermaine DeCoste, which has been listed. So what the state did in the supplemental discoveries list that he had been given testimony, gave the history of the different depositions that he testified in and the different cases that he had been questioned in. In the Jermaine DeCoste case, Mr. Varner is actually a witness / the intended victim. That's a case that is pending in CRI in front of Judge Salem. So like I said, that one's already been listed. And then the only other cases are the current case.
And I don't mean to interrupt either. Can you, if you can say for the record clearly, which of the discovery exhibits that you have filed by date or by title that this has already been disclosed?
Yes, ma'am. If I can I'll pull them up in our system so I can see all of them at once.
Okay.
It may be the 6th, if that helps.
The 6th supplemental is the one that I listed, the
Cannon's priors.
Cannon's priors, as well as Mr. Varner's testimony in the Mark Clayton case.
Okay.
And then it was state's 4th supplementary. I gave an entire history of Mr. Varner's testimony in the Jermaine DeCoste case, as well as a list of cases that he had also been questioned in, which I know that it may be somewhat confusing to look at, but they're largely the same cases. So as the court is aware, there's the Christopher Brown and Derek Hudson case, which are one case together. They are co-defendants, which is the one charge that one of the cases that Mr. Varner had pled to. Then there's Abdul Robinson Sr., Abdul Robinson Jr., and those are Mr. Cooper's cases, as well as Hakeem Robinson and Leroy Whitaker. So that was all one case. And then Jannard Cannon is also a co-defendant in the case involving Derek Hudson and Christopher Brown, as well as Abdul Robinson Sr. is also a co-defendant. in that case. So that's, like I said, that's state's fourth supplemental. So there's the Mark Clayton case, which is listed in state 6. There's the Jermaine DeBose case where he is a witness / intended victim, which is listed in state's 4th. And then there is the Chris Brown, Derek Hudson case, which I think is in state's 1st supplemental discovery. I'll have to look.
That we have, Your Honor. That's 2020 CF 7285. He's testifying against Christopher Brown, Derek Hudson, and possibly Janera Smith.
And I apologize. I also have in state's 3rd supplemental discovery where Chenard Cannon is listed as being charged in the case involving Derek Hudson, Chris Brown. And then there is the pending case involving Mr. Robinson and Mr. Whitaker and Dual Robinson Jr. and Dual Robinson Sr. So that is the 4th case. And then finally, my case. So as it relates to Mr. Bonner, it is just those 5 cases that the state is aware of. So my current pending case, Mr. Cooper's current pending case, Mr. Hutton's current pending case, which is the Chris Brown, Derek Hudson case, the Jermaine DeBose case, which is currently pending in CRI, and then the Mark Clayton case, which is to the state's belief it is resolved. And then as it relates to Mr. Cannon, there is just the 2 cases, which is the current pending case involving Mr. Brown and Mr. Hudson, and then this case.
Okay, and all of those cases were previously disclosed in supplemental discovery exhibits?
Yes, ma'am. Between the 1st, the 3rd, the 6th, and the 7th, and the 4th, I think everything has been covered. And then, like I said, the what I labeled as abundance of caution, I guess I'm now incorporating the state's response to the motion to compel as well, including some additional information, which was under paragraph 2 of the response. Which
All
is
right.
out.
And just also for clarity of record, and that's why I asked, I guess, the motion was filed in both cases. Your response was only filed in your case.
Yes, ma'am.
But not in Mr. Cooper's case.
So in Mr. Cooper's case, Mr. Cooper, I made the distinction between informant witnesses and cooperating co-defendant. So I never listed them as category M. I just spread everything out between Brady and category A. Mr. Cooper listed everybody as an M. So everything has been disclosed, I believe, in Mr. Cooper's case under M as well.
Okay. So, all right. And so, Mr. Cooper, anything else you need to add or want to add to these disclosures?
No, Your Honor, I've made all the disclosures.
Okay. So, counsel, then did you believe that there were other cases other than the 5 for Barner and the 2 for Cannon that they were involved in that hadn't already been disclosed to you in the state's supplemental discovery exhibits?
Yes, but the presentation today changes it. So in the previous conversations and highlighting again the one with ASA Atkinson, my fear was that there were, and it was enough so for me to have the basis for the motion to compel when they were trying to say, well, on these other cases, he's just a witness. You know, for example, Jermaine DeBose, he's just a victim. That gave me pause and concern that these were not exhaustive lists of all the cases, not where they're cooperating, but all the cases where they're a witness for the government, be it for whatever reason. If this is the exhaustive list that the government is giving us, I trust that it's exhaustive. Obviously, there's a problem if it's not the exhaustive list later on, but with this, we're now able to formulate the response on the motion to reduce bond. We know the extent of the cooperation, and it's being clarified.
Okay. All right. Well, then I think that resolves this matter because yes, I mean, and I do agree, it doesn't matter how you classify the individual, whether as a witness, a victim, a cooperating co-defendant, or an informant, if there are cases in which they are testifying as a state witness, that is an area that is permissible to cross-examine a witness on, whether at a hearing or a trial. So with this representation by the state, that these are the 5 for Mr. Barner and the 2 for Mr. Cannon, and I think your other question was to know what their priors were, and Mr. Cannon's, it appears, were previously listed. Have you listed, either one of you, the priors for Mr. Barner?
So I believe Mr. Barner only has the one prior, which is the case involving Mark Clayton, and then as the court is where he's entered the plea in the current pending cases for Mr. Hutton's case and Mr. Cooper's case.
Okay,
And Judge, in my case, I did disclose his prior record as well.
okay. All right, so do you have that for Mr. Barner and Mr. Cannon? You have those discovery disclosures where their prior record has been revealed to you?
I do have Mr. Barner's, Your Honor. On Mr. Cannon, what we have for Mr. Atkinson, you referenced it a moment ago, was that Mr. Cannon has 4 priors. I would ask that the government be ordered to provide to us what those priors are. Obviously, they don't have to provide us a certified convictions, but the case names, the styles, instead of just saying he has 4 convictions for us to go find. Because if we find a different one, then how are we to know that we have the 4?
And I haven't seen the 6 supplemental exhibit here recently, but are they disclosed there, or is it just the number of felony convictions?
Just the number.
Okay. So then could you please provide to defense what those case numbers and crimes are for the 4 felony convictions for Mr. Cannon?
Yes, ma'am.
Okay. Can you do that by the end of this week?
Yes, ma'am.
Okay. All right. Is there anything else from either side?
Nothing from the state.
No, Your Honor, thank you. And thank you again for allowing us to appear via Zoom. We were able to appear in Leon County minutes before appearing before Your Honor in Duval County, and it really makes it easier.
Well, my pleasure. We now have to then pick another date for the next pretrial conference or the next court appearance for Mr. Robinson.
And
So
I forgot, I was not in here, I was in Judge Barella last week for the trial, but there was a question as to what was going to happen on my case for speedy trial, if we were going to set it or if counsel was going to wait.
correct. Yes, because I do have speedy trial in Mr. Atkinson's case and case ending 2332 running June 27 of 22. And I believe you all said you would perhaps talk to your client or decide what to do. Otherwise, I need to set this matter for trial in June.
If Your Honor would allow, and I preface it with, again, we're not ones to play speedy games. I do want to have a conversation with my client and with Ms. Kawass, if the court could set the June date. And we'll make sure to be in communication with the government beforehand. Obviously, to put it on the record too, we haven't, we're focusing the depositions on the first case, not on the second case, just to give the court an idea of, how we're proceeding on that case.
All right, so I'm not sure what you wanted me to do then. You want me to set it for trial in June, or do you want me to just pass it another week or 2 to allow you to talk to Mr. Robinson about waiving speedy trial in the 2021 case?
If the court would do the June date, the only reason is we're currently under a speedy demand, not natural speedies, but a speedy demand in Leon County. And we're going to be starting trial in about 2 weeks, and that's going to be a couple weeks in May. So it's going to be hard to set anything. If the court would allow an early June date, we expect to be out of trial by Memorial Day.
Okay, then I will set the 21 case, I guess, for trial. I can do June 13 or June 6th. That was his original trial date in the 20 case, but now that's not going.
I'm unavailable the weeks of the 13th and the 20th, so I'd ask for either the 6th or the 27th.
Yeah, I'll do the 6th then. I don't want to do it the day speedy runs.
Okay, works for the defense.
Okay, then we'll set June 6th jury selection, May 31 final pre-trial, and that is in case 21 CF 2332. I'll get a trial order out and we'll do, so do you want to just leave it for May 31 or do you want to come back here for an intervening pre-trial between now and then? I mean, I know you said you'll be in trial, so.
It's lots going on. So I think that another date is going to be necessary. Now, if the government gives a response of the priors by the end of this week, I still owe to the court my response on the motion or the reply on the motion to reduce bond. It's going to be very short. It's going to address specifically these 2 cooperators. Depending on when the government gets me those items, I expect to be able to turn around a reply within 72 hours to the court.
Okay, Yeah, I know I still have to rule on that, and that is still under advisement pending the response by you all. And so certainly I can do that via pleadings. I don't know that we need to come back for any, or do we need to come back for additional argument? I mean, if they've made their argument, I've just given you an opportunity to respond. And so if you respond via pleading, I can certainly enter my order via pleading, since you all are going to be wrapped up in trial for the next 2 weeks or so.
Yeah, we made the brunt of our argument, obviously, in the previous motions and the previous hearings. The only thing that we're replying on right now is what weight we think that the court should give in Mr. Atkinson's case to these two cooperating witnesses, because the case is based almost entirely on them. And that's because we get into a factual argument on that case. That bond is currently set at 3 million. The other one is set at 1 million. And so the argument is going to be specifically tailored as to that. I don't need to come back in and argue before Your Honor, Mr. Robinson's, his net worth, his ability to pay, stuff like that. Those arguments, we've already made those.
Okay, well then let's just come back here May 31 for final pretrial then. And if y'all need to add it on for any reason, if your trial goes away or you'll have time or anything else needs to be addressed, we can certainly add it on before then, but otherwise we'll just leave that as the next court date.
Would the court potentially be ruling on the motion before that?
Yes, if y'all turn in all the pleadings appropriate. I mean, I know you're waiting on them. I've given him till the end of the week to give you the information. Then you all have to draft your response. And when I get the response, I can enter an order just based on the pleadings. Depending on when I get it and what my trial schedule is. I am supposed to be in a death penalty trial beginning May 9th. So we'll see if that goes then or if it gets bumped to the 16th.
We fully appreciate and understand that the court has a process to go through. To assure the court too, there's been no change of circumstance on our end from what we presented via testimony with the court, and we can put that in the motion as well too, that we still have the same support.
Okay. All right, very good. Then May 31 for final pretrial and pretrial in the other matter.
Thank you, Your Honor. Good seeing you.
Thank you.